A three-judge panel from the Fourth Circuit Court of Appeals has roundly rejected Donald Trump's attempt to justify in any way the abduction and delivering of Mr. Abrego Garcia to a terrorist gulag prison in El Salvador, meant to hold true terrorists, although when you look into it, there's some weird political dictator stuff going on here, both in El Salvador now and in the U.S., but the most important part is that Mr. Abrego Garcia was not given any due process, as in the legal process that is due to you under the U.S. Constitution. No matter who you are, whether you are a citizen or a non-citizen, an innocent or a criminal, whether you have a parking ticket or whether you have committed capital murder, you are due a legal process. Legal process must be meaningful. You must have an opportunity to respond. The judge must issue a reasoned opinion, that sort of thing. For illegal immigration and legal immigration, we have a much reduced due process right. But you still get notice, an opportunity to respond in a abbreviated hearing, in an abbreviated setting, and then the judge will make a decision about whether further action or litigation is warranted in order to establish your rights or not. And the Trump administration is refusing to provide any details whatsoever. The cowardly president has even now washed his hands of any knowledge of what's going on, as if he had nothing to do with this from the very beginning. The Fourth Circuit Court of Appeals ruling is remarkable. You will not see court rulings worded this strongly very often. So please buckle up, grab your popcorn. Please share this with your friends. Please like and subscribe. Please tell the world how you feel about the violation of your due process rights in America. You can be disappeared, and what are you going to do about it? So here we are, filed April 17th, before Judge Wilkinson, King, and Thacker. Wilkinson is a Reagan judge, and King and Thacker are Obama and... shoot, I forgot the last one. Upon review of the government's motion, the court denies the motion for an emergency stay pending appeal and for a writ of mandamus. The relief the government is requesting is both extraordinary and premature. While we fully respect the executive's robust assertion of its Article 2 powers, we shall not micromanage the efforts of a fine district judge attempting to implement the Supreme Court's recent decision. It is difficult in some cases to get to the very heart of the matter, but in this case it is not hard at all. The government is asserting a right to stash away residents of this country in foreign prisons without the semblance of due process that is the foundation of our constitutional order. Further, it claims in essence that because it has rid itself of custody, that there is nothing that can be done. This should be shocking, not only to judges, but to the intuitive sense of liberty that Americans far removed from courthouses still hold dear. The government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident of its position, it should be assured that position will prevail in proceedings to terminate the withholding of the removal order. The government must prove by a preponderance of the evidence that the alien is no longer entitled to a withholding of removal. Moreover, the government has concluded that Abrego Garcia was wrongly or, quote, mistakenly deported. Why then should it not make what was wrong right? The Supreme Court's decision remains, as always, our guidepost. That decision rightly requires the lower federal courts to give due regard for the deference owed to the executive branch in the conduct of foreign affairs. That would allow sensitive diplomatic negotiations to be removed from public view. It would recognize as well that the facilitation of Abrego Garcia's return leaves the executive branch with options, in the execution of which the courts, in accordance with the Supreme Court's decision, should extend a genuine deference. That decision struck a balance that does not permit the lower courts to leave Article 2 by the wayside. In other words, he keeps his executive power and he makes decisions for the executive. They're not taking away his executive power. They're telling him what he has to do, but without telling him how. The Supreme Court's decision does not, however, allow the government to essentially do nothing. It requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. Facilitate is an active verb. It requires that steps be taken, as the Supreme Court has made perfectly clear. Quote, "The government should be prepared to share what it can concerning the steps it has taken and the prospect of further steps." The plain and active meaning of the word cannot be diluted by its constriction, as the government would have it, its constriction to a narrow term of art. We are not bound in this context by a definition crafted by an administrative agency and contained in a mere policy directive. In other words, not legislative action, not a Supreme Court ruling. Thus, the government's argument that all it must do is remove any domestic barriers to Abrego Garcia's return is not well taken in light of the Supreme Court's command that the government facilitate Abrego Garcia's release from custody in El Salvador. Facilitation does not permit the admittedly erroneous deportation of an individual to one country's prison that the withholding order forbids, and further to do so in disregard of a court order that the government not so subtly spurns. The word facilitation does not sanction the abrogation or the elimination of habeas corpus, which is your right to be heard before a court about this kind of thing, through the transfer of custody to foreign detention centers in the manner attempted here. Allowing all this would facilitate foreign detention more than it would domestic return. It would reduce the rule of law to lawlessness and tarnish the very values for which Americans of diverse views and persuasions have always stood. The government is obviously frustrated and displeased with the rulings of the court. Let one thing be clear. Court rulings are not above criticism. Criticism keeps us on our toes and helps us do a better job. Criticism need not be stilled. It is active obstruction or defiance that is barred. Court rulings can overstep, and they can further intrude upon the prerogatives of other branches. Courts thus speak with the knowledge of their imperfections, but also with a sense that they instill a fidelity to the law that would be sorely missed in their absence. Energy in the executive is to be much respected. It can rescue government from its lassitude and recalibrate imbalances too long left unexamined. The knowledge that executive energy is a perishable quality understandably breeds impatience with the courts. Courts, in turn, are frequently attuned to caution and are often uneasy with the executive branch's breakneck pace. The differences do not end there. The executive is inherently focused upon ends, the judiciary much more upon means. Ends are bestowed on the executive by electoral outcomes, means are entrusted to all of government, but most especially to the judiciary by the Constitution itself. The executive possesses enormous powers to prosecute and to deport, but with powers come restraints. If today the executive claims the right to deport without due process, in disregard of court orders, what assurance will there be tomorrow that it will not deport American citizens and then disclaim responsibility to bring them home? Which, by the way, check the news, that recently happened. And what assurance shall there be that the executive will not train its broad discretionary powers upon its political enemies? Also something, if you've looked at the news recently, has happened. The threat, even if not the actuality, would always be present, and the executive's obligation to, quote, take care that the laws be faithfully executed would lose its meaning. Today, both the United States and the El Salvadoran governments disclaim any authority or responsibility to return Abrego Garcia. We are told that neither government has the power to act. The result will be to leave matters generally, and Abrego Garcia specifically, in an interminable limbo without recourse to law of any sort. The basic differences between the branches mandate a serious effort at mutual respect. The respect that courts must accord the executive must be reciprocated by the executive's respect for the courts. Too often today, this has not been the case, as calls for impeachment of judges, for decisions the executive disfavors, and exhortations to disregard court orders sadly illustrate. It is in this atmosphere that we are reminded of President Eisenhower's sage example. Putting his personal opinions aside, President Eisenhower honored his, quote, inescapable duty to enforce the Supreme Court's decision in Brown v. Board of Education 2 to desegregate schools with all deliberate speed. This great man expressed his unflagging belief that the very basis of our individual rights and freedoms is the certainty that the president and the executive branch of government will support and ensure the carrying out of the decisions of the federal courts. Indeed, in our own late executive's own words, unless the president did so, anarchy would result. Now the branches come too close to grinding irrevocably against one another in a conflict that promises to diminish both. This is a losing proposition all around. The judiciary will lose much from the constant intimations of its illegitimacy, to which by dint of custom and detachment we can only sparingly reply. The executive will also lose much from a public perception of its lawlessness and all of its attendant contagions. The executive may succeed for a time in weakening the courts, but over time, history will script the tragic gap between what was and all that might have been, and law in time will sign its epitaph. It is, as we have noted, all too possible to see in this case an incipient crisis, but it may present an opportunity as well. We yet cling to the hope that it is not naive to believe our good brethren in the executive branch perceive the rule of law as vital to the American ethos. This case presents their unique chance to vindicate that value and to summon the best that is within us while there is still time. In sum, and for the reasons foregoing, we deny the motion for the stay pending appeal and the writ of mandamus in this case. It is so ordered. The strength and gravity with which the appeals court spoke, don't overlook that. I tried to give it my energy. We live in unprecedented times. Not that no one has ever disobeyed the Supreme Court before. I went over in my last video. That has happened a couple times. This disobedience is unprecedented. The complete elimination of due process, not during time of war, not with congressional approval, in violation of the acts that the executive cites as the basis for his lawlessness. The emergency powers granted, they don't cover this type of act. There's a reason why the rule of law needs to apply equally to all, because it crumbles when it is not. Our civilization works because we believe in it and participate in it. When we stop participating in it, when we stop believing in it in the sense of maintaining it and honoring it and obeying it, it falls apart. The Constitution gives the executive the power to execute the laws faithfully. That's all it does. It's actually a very short Article 2 in our Constitution. It does not grant the president any power beyond executing the laws as Congress has made them and as the judges of the Supreme Court and the lower courts have interpreted those laws. We agree to live by these rules. Violations of these rules break the social contract that binds our civilization together, in this case, the United States Constitution. You saw the Fourth Circuit Court of Appeals give the Trump administration a graceful way out, claiming that they still have faith that the executive will do the right thing. Let's see what happens. I have my doubts. Even if Abrego Garcia is returned now, I believe a tremendous amount of damage has been done to the trust of both the court system, but more so to the administration, depending on your perspective. If you believe in the rule of law, you probably feel like the Trump administration has this is an egregious violation. This is the most violation of the social contract you can get, to completely disregard the basis for our laws, due process, the foundation of our legal system. If you don't believe in the rule of law and you believe in the executive as a king, then you probably don't like the fact that courts can intervene. But I have words for you. You are living under the wrong constitution if you expect that the president is a king and the courts have no power. And you wouldn't want to live in that world once you saw what the consequences of that are. That level of ignorance is part of the problem. We Americans, for some reason, have completely lost our way. Many, maybe 40% of Americans or more really have no idea what their rights actually are or why the government works the way it does, why it doesn't work sometimes, a lot of the time. And using this ignorance as a playfield for misinformation, con artistry, scams and fraud, self-enrichment, nepotism. These are not the positive American values, and you are not powerless. You may be watching from the sidelines, unable to stop this yourself, just as I am. But you can still call your congressman. You can still donate to politicians that are working to make the world a better place. You can go to protests and town hall meetings and state your opinion. You need to participate civically, or else what's about to happen is going to be done to you just like everyone else. Let me know what you think in the comments below.